Garcia. That is your true and correct name, sir?
Yes, Your Honor.
And your date of birth, 9/18/1992.
Correct, Your Honor.
And you recognize your attorney, Mr. Mark Rosales?
Yes, Your Honor.
And Mr. Rosales, you recognize your client, Mr. Garcia?
I do.
All right. Then I believe Ms. Espinosa representing the state. This is a plea agreement case. Would you like to state the plea agreement on the record?
Yes, Your Honor, under both cause numbers, which are 2021 0D02838 and 2022 0D01807. On each of them, it's to the lesser included offense of assault causes bodily injury, 180 days.
Oh. Okay. All right. So we got,
And
did
Your
you say
Honor,
100, you said 180 days county jail?
280 days, Your Honor.
280 days.
And there are 2 misdemeanors that are also going to be dismissed as part of the plea agreement.
And he has at least 280 days. So these are time served pleas, correct?
Correct, Your Honor.
Okay.
That's right.
Now, just to make sure, we could have you come into court in person and do these hearings. Do you waive your presence in coming into open court and are satisfied doing these by Zoom hearing?
I do them here, Your Honor.
Okay, you're satisfied with that, Mr. Rosales?
I am, Your Honor. Thank you.
Okay. So, and is that your understanding of the plea agreement then, Mr. Garcia?
Yes, Your Honor.
Is it also your understanding of the plea agreement, Mr. Rosales?
It is, Your Honor.
Now, you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose harsher than that, you could withdraw your pleas and we could proceed to trials on both of these matters. But if I follow the plea agreement, it is final. You cannot appeal these cases. You cannot withdraw your appeals without my consent. And since these are time served pleas, there still would be the implication that they would appear on your record as convictions for Class A misdemeanor assaults. You understand that?
Yes, Your Honor.
Now, I have in front of us some documents marked State's Exhibit 1, the guilty plea and waiver forms in these cases. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
I did, Your Honor.
Did you, you did read them before you signed them?
Yes, Your Honor.
Did you understand what you were reading and signing?
Yes, Your Honor.
Did your attorney further explain to you the meaning of the documents?
Yes, Your Honor.
Did you understand what he was telling you?
I did, Your Honor.
Do you have any question about the meaning of the documents?
No, Your Honor.
So that there's never any question, let me briefly explain to you what they mean. Primarily 2 things. First, you're coming into court telling me through judicial confessions, yes, Judge, I did commit these 2 Class A assault misdemeanors. And secondly, you're telling me that you understand you're giving up some valuable rights here today. The most important of those rights, the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Yes, Your Honor.
Understanding that, how do you plead then to these Class A misdemeanor assaults, guilty or not guilty?
Guilty.
Are you entering your pleas of guilty freely and voluntarily?
Yes, Your Honor.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, Your Honor.
Did anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, Your Honor.
Now, you understand I have to punish you somewhere within the general punishment range, which is from 1 day to 1 year in the county jail, a fine not to exceed $4,000. You understand I'll sentence you somewhere within those general guidelines.
Yes, Your Honor.
You are a U.S. citizen?
I am, Your Honor.
And how old are you, sir?
30.
How far did you go in school?
GED.
So you can certainly read and write the English language.
Yes, Your Honor.
Have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
No, Your Honor.
Suffered any serious head injuries?
No, Your Honor.
And you're telling me you're mentally competent, you understand everything that's going on this afternoon.
I am, Your Honor.
Now, counsel, you've had time to go over the facts and circumstances of these cases, the legal aspects of the cases, and had time to evaluate your client's mental status.
I have, Your Honor.
And based on all that, are you representing to me that you believe he is mentally competent to enter this plea?
I am.
All right. Then based on your representations, Mr. Rosales, your representations, Mr. Garcia, the court's observations of you in court, both here today and prior occasions, I find that you're competent to enter the plea. The state may summarize the evidence.
Yes, Your Honor, had the state proceeded to trial in these cases, the state would have proven beyond a reasonable doubt each and every element in the lesser included offense of assault causes bodily injury. In each case, in the 2838 and 1807, the state moves to introduce state's exhibits 1 through 2, which are the plea papers and the 3914 disclosure form.
No objection.
Received. Based on the evidence before the court finds the evidence sufficient to find the defendant guilty of the lesser included offenses of Class A misdemeanor assault. I'm ready to move on to the issue of punishment. When we talked about your cases earlier, I think it was noted that you had been living with your mother. When you get out of jail, is that your plan to go back and live with her, or you have other plans?
I have other plans, Your Honor.
Okay, what are you planning to do?
I'm gonna probably go out to Midland, look for a job in the oil rigs.
Oh, okay. Well, they have good paying jobs out there.
Yes, sir.
And do you think you'll have someplace to stay? Do you know anybody out there?
I have an acquaintance out there and he could probably help me out.
Good, good. Well, that's a good plan, and that'll get you back on your feet financially. And so I hope that works out well for you. And then I guess I will follow the recommendation in this case. I think you said 280 days in the county jail. And that is the sentence of the court. In both cases, they run concurrent. I give you full credit for all the time that you have served, which means these are time served pleas. I understand they're going to dismiss the misdemeanors and then you will be released. So you will have, you'll obviously have some time to get out to Midland, and good luck to you, sir.
Thank you, Your Honor. Thank you,
Thank
Mr.
you.
You're
Thank you.
welcome. Good luck. Thank you, Judge. May I be excused?
You may.
Thank you. Nice to see you.
Thank you. And now I believe next we have a case with Mr. Solis, and that is Mr. Eric Primer.
Quimmer?
Primer.
Quimmer.
Mr. Solis, I'm sorry, I just got your email, but the case, the misdemeanors out of CC2, CCR2, I'm sorry.
Right, but oftentimes the district court can sign the dismissal if you're forward to. Do you sign the dismissal for misdemeanor court, Your Honor?
Not usually, but I mean, if I have their consent, I will.
Yeah, that's what I was asking, was wonder if you had the consent from CCR2.
Who's the judge there?
Judge
That would be
Anchondo?
Judge Anchondo.
Oh, I'm sure he would. I was going to speak to him early this morning on another case. I have not had the chance to speak with him. As soon as I speak with him on that case, probably this afternoon, I'll ask for that consent and I then can sign it presiding for him.
Either way,
Perfect, thank you.
I'll go ahead and send an email to the misdemeanor attorney to dismiss it as well.
All right, so that way we'll get it done.
Yeah.
All right, well, very good. So now, again, there's two cases here, I believe. Cause 2022 0D05563 and 2022 0D05823. The state of Texas versus Eric Lee Primer. And I would, is that your true and correct name, sir?
Yes, sir.
And your date of birth, 3/8 of 1979.
Yes, sir.
You recognize your attorney there, Mr. Solis.
Yes, sir.
Mr. Solis, you recognize your client there, Mr. Primer.
I do, Your Honor.
Okay. Now, the state's attorney, Ms. Espinosa, this is a plea agreement case. Would you like to state the plea agreement on the record?
Yes, Your Honor, to 2022 0D05563, which is state jail, it's 6 months state jail. And then on 5823, it's 3 TDC.
6 months state jail on the 5563. And then on the 5823, it is 3 years TDC, and these will run concurrent. And I will give you credit for all the time that you have served, and it's somewhere close to 130 days right now.
And
And-
we're dismissing 2022-0C06289.
Dismissing what number?
2022-0C06289.
All right. Very good. And is that your understanding of the plea agreement, Mr. Solis?
It is, Your Honor.
Is it also your understanding of the plea agreement, Mr. Crimer?
Yes, sir.
Now, you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you could withdraw your plea and we could proceed to a trial on these matters at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your pleas. You cannot appeal these cases without my consent. You would be transferred, in this case, I believe, to the Texas Department of Corrections at their earliest convenience, and to serve out whatever would remain of that the burglary of habitation case. You understand that?
Yes, sir.
Now, we have in front of us some documents marked States Exhibits 1, the guilty plea and waiver forms in both of these cases. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, sir.
Did you read them before you signed them? Did you understand what you were reading and signing?
Yes, sir.
Did your attorney further explain to you the meaning of the documents?
Yes, sir.
Did you have any question about their meaning?
No, sir.
So that there's never any question, let me briefly explain to you what they mean. Primarily two things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit these offenses. And secondly, you're telling me you understand you're giving up some valuable rights here today. The most important of those rights, the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Yes, sir.
Understanding that, how do you plead to both of these indictments, guilty or not guilty?
Guilty, sir.
Are you entering your plea of guilty freely and voluntarily?
Yes, sir.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, sir.
Did anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, sir.
Now, you are a U.S. citizen,
Yes, sir.
and how old are you, sir?
44.
How far did you go in school?
11th grade.
So you can read and write the English language.
Yes, sir.
Have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
No, sir.
Suffered any serious head injuries?
No, sir.
And are you telling me you are mentally competent? You understand everything that's going on here this afternoon?
Yes, sir.
Counsel, you've had time to go over the facts and circumstances of this case, the legal aspects of the case, and had time to evaluate your client's mental status.
Yes, sir, I have.
And based on all of that, you believe he is mentally competent to enter these pleas.
I do, Your Honor.
Okay, then based on your representation, Mr. Solis, your representation of Mr. Crimer, court's observations of you in court, both here today and prior occasions, I find that you are competent to enter the plea. The state may summarize the evidence.
Yes, Your Honor, had the state proceeded to trial under 5563, state would have proven beyond a reasonable doubt each and every element in the offense of burglary of building as alleged in the indictment. Furthermore, had the state proceeded to trial under 5823, the state would have proven each and every element under the offense of burglary of habitation as alleged in the indictment. The state moves to introduce states exhibits 1 through 2, which are the plea papers and the 3914 disclosure form under each of these cause numbers.
No objection, Your Honor.
They are received. Based on the evidence before the court finds defendant guilty in both of these indictments as charged. I'm ready to proceed upon the issue of punishment. Now, I did want to remind you that if you wanted, we could bring you into court, open court here at the courthouse and do these pleas here. Or of course, if you wanted to do them as we're doing it here on Zoom, you could waive that and we can continue and finalize these pleas here today. Did you want to go ahead and finalize the pleas here today under Zoom hearing?
Yes, sir.
And Mr. Solis, you concur in that decision?
I do, Your Honor.
All right, and then we will proceed. Now, after you finding you guilty here, we went over some other matters the other day at the bond hearing. Let me see here. When you get out, are you going to have somewhere to stay and live?
Yes, sir.
And where are you going to go when you get
My
out?
stepmom,
You live with your stepmom here in El Paso or somewhere else?
here in El Paso.
Okay. And I think you said you might have a job lined up. Hopefully you will. What were you going to do?
Landscaping,
Hmm. All right. Well, you have a considerable amount of time built up here, and these are not extremely long sentences. In fact, they're less than you have served in the past. And hopefully you will be out soon and you can get back to stay with your stepmother and help her, and also maybe get back to work. And hopefully you won't get in any more trouble again, because there's several convictions on you over the years, and they could even in this case they could have tried to make these for very harsh minimums. Sometimes they go up to 25-year minimums on habitual indictments. So be careful. Don't get in trouble again.
no, sir, I'm not gonna get in trouble anymore.
Okay, good luck to you,
Yeah,
sir.
and we've had
Yes.
that discussion, Your Honor. In this particular case, cases, the state could have easily opted to habitualize, but that didn't happen. So we've had that discussion. Next time he may not be so lucky.
Indeed. All right. Well, good luck to you. I will follow the recommendation. 6 months in the state jail on the 5563 case and 3 years in the 5823 case, giving you all credit for the time that you've served, and the cases run concurrent. So good luck to you, sir. Right. Let's see if we are going to proceed on with Mr. Jorge Montoya, because I understand that is the one that we need the interpreter for.
And be excused, Your Honor. Thank
You may. Thank you very much, sir. Have a good day.
Thank you, Mr. Espinoza.
Thank you. Take care.
You know,
All right. Okay, and I think Ms. Pettis is going to represent you here in this case. Is that correct?
Yes, Your Honor, but I know Mr. Hughes was here before I even logged in, so I don't mind waiting until.
Well, I know, but
That's okay. The interpreter needs to be taken care of. I don't mind waiting my turn, Judge. I'm good.
All right. Well, I was trying to get that because the interpreter sometimes needs to get on to another court.
Yes, sir.
So
Not a problem.
that's why I went in that direction. And we'll get done here. So you are now the attorney of record for Mr. Montoya.
Yes,
And
correct. Your
today,
Honor.
Mr. Montoya brought forward. Do we know what the, let's see, let me look at this. Now, was he in the comp court, or has he now been released from the comp court?
He's been released from the comp court, Your Honor. He was previously under Mr. McLean. He filed a motion to comp.
Right.
He came back as competent.
Okay. When was that? Do you know?
I believe that was about a month ago. The case was recently transferred to me from Mr. McLean. So prior to the transfer to me, he was found competent.
Okay, now let's see. We're going to have to do this through the interpreting box here.
Yes, Judge.
And let's see, you got to push the one that says interpretation.
Correct.
Okay, and then you go to
See,
English.
English for me. Got
Correct.
it. Okay. I can't. All right. So now, like I said, the defendant has been in custody because of these competency issues for about, 121 days? And what is the amount of bond? Looks like 34,000. Is that right?
Yes, Judge.
And I was forced to revoke his bond because this was back in December of this year, but he wasn't reporting. It appears that was the reason. Because he had been out on bond. He'd been out on a PR bond, right? Okay. Now let's go over then briefly the facts of the case. Do you want to go over those with me briefly, Ms. Espinosa? I think I have most of them.
And Your Honor, if I may, before we start, he also has a case in CC1 and Judge Reyes has granted the court permission to address that bond as well.
Okay, so I will also County Court 1 bond. What is that at?
I believe that one is at 7,500. It's under cause number 2022-0C01540.
I'm showing 2,000.
No, I'm sorry. Okay, 2,000.
It's okay.
2,000 on that one and 34,000 on this one. And on the revo of the bond is the revo of the PR bond. It is it was for not appearing. Is that right? Because I have a note here, he was not showing up to PR bonding.
Yes, Your Honor, failed to report as advised by the court. Doesn't say any specific.
I show a
since-
6/24 of 22, no show with PR bonding. Oh no,
Yes.
6/24 of 22 is the date of this
The date.
incident.
So it says since July 20th of 2022, he stopped reporting. So a month later.
Yeah, he didn't report very long. Okay, so what was this case about briefly, Ms. Espinosa?
Yes, Your Honor, and this is two minor children. Give me 1 second. I had to open my notes. This occurred on June 24th, 2022. There were two children that flagged down police. So the defendant is their uncle. They said that he had assaulted them. What the complaining witness is 14 years old, and the witness is the grandmother. The defendant was looking for his keys. He got upset. He started yelling at them. The complaining witness yelled back that they didn't take anything. The defendant pushed him onto the couch. And then I guess he pushed him off of him. He ran into his room. He slammed the door. The defendant came in and pushed the complaining witness onto the floor, started kicking him in the torso, grabbed him by the neck and began to choke him. The grandmother, which is the witness, had to intervene. And then they left he left the residence. And I think she went with him because it says she went with the complaining witness and his brother. They flagged down the neighbor who then called 911. Police said that they did observe scratches to his right hand and left hip and a footprint on his right pant. The grandmother refused to cooperate or answer any questions, and CPS was called.
Okay. Now, we also have an extensive criminal history. The defendant's been to prison how many times? 2 or 3 times?
3 times, Your Honor.
And I show in 08, DWI 3, 2 TDC. Is that right?
Yes, Your Honor. And then 2010,
2010, what was that for?
DWI 8 TDC. And then 2014, DWI 2 TDC.
So 3 times he's been to prison for DWI 3. And now for assaulting children. And now he's not reporting. Okay, what kind of bond is he able to make, Ms. Pettis?
Your Honor, at this time, my understanding from speaking to my client, he has about $300. My understanding from speaking to Mr. Montoya is that he is innocent. The allegations are not as stated by the state. My investigator, Metzalida Ramirez, is working on making contact with the grandmother. It is my understanding that the alleged complaining witness was adopted by the grandmother who is mom of my client. They all live in the same household. So I have submitted an investigation request asking that my investigator reach out to the grandmother, since the alleged complaining witness is a minor, to inquire as to what happened and to obtain a non-prosecution affidavit if that is what they are wanting to do. My understanding from speaking to my client is he has about $300 right now. He does do construction, yard work. He understands the importance of reporting. I have stressed that importance to Mr. Montoya. He understands that if the court does grant him the second opportunity to be released on bond, that he will comply and provide updated information to PR, as well as maintain contact with myself.
Do you have any idea why he didn't report after only being out for such a short period?
Your Honor, I don't know if it was perhaps a language barrier with regards to him being a Spanish speaker. His highest level of education is 7th grade. So there may have been some type of miscommunication, but I have explained to Mr. Montoya that he must report as court ordered.
All right. Is there anything else you would like to say on your client's behalf, or is there anything he'd like to say?
No, Your Honor, we are just respectfully requesting that the court consider granting him the PR bond and the alternative, a bond reduction. I'm not sure that with regards to the pending felony, given the nature of the charge, he does not qualify for straight PR bond under the SB 6 bill as of 2021. So we are asking for a reasonable bond reduction with regards to that charge and a PR bond in the criminal mischief.
Does the state have a position on this matter?
Your Honor, I haven't been able to personally speak with the complaining witness. I will leave it in your discretion. However, we would ask at this time for no contact with the complaining witness if he were to be released.
All right. It might be
Your Honor,
difficult.
I
if they
have
all live in
updated-
the same place.
I have updated the recommendation at this time to 5 TDC, considering the defendant's history. But I will be making contact with the complaining witness soon.
All right. All right. Is there a trial date set?
Yes, Your Honor, I believe we're set for May or April, I'm sorry.
Of what year? This year?
This year, yes. April 17th.
April 17th. All right. Well, I'm going to respectfully decline the request to reduce the bond. Defendant's record is very excessive. And the fact that he stopped reporting almost immediately does not indicate to me that, you know, I'm not confident that he would appear in light of at least a 5-year prison sentence recommendation. So it is declined
Thank you, Your Honor.
or denied. Thank you.
May I be excused?
You may.
Thank you, Your Honor.
Okay, let's proceed on with Ms. Casio. You may. Thank you so much. Oh. Oh, okay. How do I?
It's good to go, Judge.
Okay, I turned it off on mine. All right. Okay, now we have a couple of cases. 2020-0D00745, 2021-0D01149, the state of Texas versus Sophia Casio. These are both possession of controlled substances. One of them is under 1 gram. One of them is 4 to 200 grams. We have had a problem with her reporting in the past. There was not at one time early on in the first case no criminal history. There was, and she pled guilty on that case where she was placed on 2 years deferred probation in 2020 under 1244B. Now, got quite a few notes otherwise. We were going to try to do at one point a safe P, but we realized that you can't do a safe P on a state jail, right?
Yes, sir.
So then we were going to do a BHRTC. We had because she had some problems reporting on probation. She wasn't good at reporting on probation either. And then she picked up this other charge. No reporting. We were going to modify her probation to, was it Aliviane?
I saw Alas Nuevas, Judge.
There was Alas Nuevas residential,
And then
2 to 3 months. But what she never showed up. Is that what happened?
Yes, that is correct. She was ordered to go into Aliviane, and once she was released from custody, she was only there for about a day or two, according to the staff member at Alas Nuevas, and she left. She didn't complete the treatment.
Okay. And so now she wants out on bond or what?
May I address the court, Your Honor?
You may, Mr. Hughes.
Judge, I had a long talk with my client, and I'm going to be honest with you. You and I did briefly discuss this a few weeks ago. The court's quite frustrated with her lack of attention to her probation. And my client informs me that she has nobody that will put up a bond for her. And I told her I think that this court, because I've known you for a very long time, is unlikely to give her a PR bond since she's not showing up for probation. If I may use this bond hearing as kind of like a pretrial, I would suggest to my colleague in the DA's office that we file motions to revoke. One case is a state jail felony. The other one is a real felony. And I've discussed this with my client. I'm not making this up on the fly. She'd be willing to take the minimum in both cases to put all this behind her and try to get a fresh start with whatever credit for time served she has coming, which is probably not a whole lot.
All right. Well, Mr. Hughes, Ms. Espinosa, I will certainly let you all communicate, in the next day or two to determine what type of recommendation would be correct. You are right, Mr. Hughes, with the defendant's track record on reporting and absconding, I simply can't do a PR bond.
Judge, I told her that. I told her that you and I have been colleagues for a very long time, and I'm familiar with the court's policies. And quite frankly, she agrees with me that she's a failure at probation and she might be just better off. I'll contact my colleague in the DA's office and we'll try to work something out. But
whatever you guys can work out that's agreeable to the both of you, I will follow. I won't punish her any more than whatever you two can agree on.
Thank you, Judge. I told her going in that this was probably a non-starter today, so she's aware.
All right, Ms. Casio, we'll take care of you. You'll hear back pretty quickly, I think, from your attorney. Mr. Hughes is good at communicating with his clients, and he's good at communicating with the assistant DA. And so they will be communicating within the next, well, maybe today or tomorrow, and maybe they'll come up with a resolution that will work for all of you. So I hope so. I'm sorry this hasn't worked out well.
Yes, Your Honor.
All right. Thank you.
Ms. Espinosa, I'll contact you tomorrow.
Okay.
What's a good time? Email or phone call?
Email is fine. I'll be in court in the morning, so.
Okay, and give me your email address real quick.
Sure, it's ev.espinosa.
Okay, gotcha. At EP County. Okay.
Mhm.
Okay, I'll get a hold of you. Thank you, Judge. May I be
Thank you.
excused?
You may.
Thank
We
you,
have,
Judge. May I be excused?
you may.
Yes.
We have one case left. That's Daniel Torres, also known as Daniel Sandoval. And
That's correct.
who's the lawyer there?
That's gonna be Melissa.
Your Honor, that's me. I'm covering for Ms. Romero. She's in court right now.
Oh, okay. Yeah, I showed Ms. Romero.
Yes, Your
Okay.
Honor, I'm covering for her.
Okay.
Good afternoon, probation officer Annette Torres for Mr. Daniel Torres.
23. Bond here. Okay. See if I've had one previously. Okay, there was the 2021 case, 1951, the aggravated assault deadly weapon, and that is, he's on probation for that case, correct?
Yes, Your Honor.
He pled guilty July 28th of 2022. He got 3 years deferred probation. And then apparently he has picked up this new charge, which is 2023 0D00452. Now, on the, I already issued the bench warrant on this case for the case he's on probation.
Your Honor, I was looking at my notes and I requested a copy of the offense report and I guess it never got back to me. And I overlooked it, Your Honor, and I'm seeing that a bench warrant was not submitted for this.
Obviously,
case.
that's my policy is when someone is on probation and they allegedly commit a new class
Your Honor.
misdemeanor or above, I wish for a bench warrant to issue.
Correct, I apologize. I
Yeah.
think that when I requested the offense report and I never, it never got back to me, I overlooked it, Your Honor, I'm sorry.
So
And Your
that's-
Honor, I would note that Ms. Romero is only on the new case. She hasn't been appointed on the revocation, probably
Right,
because.
I will
Yeah, there's
probably
no
have to,
bench warrant.
because there's nothing to appoint. because I-
Right,
I
right.
will
So
make
we're
sure
only
that-
arguing the new case today, Judge.
Right, well, I know, but I will appoint you on the other case, because that would be the best policy.
Of course. Thank
Now,
you, Judge.
now, what is this new case, he's been in jail for 52 days. And what is the bond on that case?
It's $40,000, Your Honor.
I mean, that's 40,000 cash surely. Let me see if I have any notes about this case. I don't think I do. Ms. Espinosa, if you could give me the allegations in this case.
Yes, Your Honor. And so I guess what happened, police or fire department, I'm sorry, were dispatched. This was 104 South Stanton, which was the defendant's residence, regarding a fire in room 209.
What is that, like an apartment or something?
Yes, because there's like a neighbor in 210 that is the one who calls initially.
Defendant was resident in downtown apartment. What was the date?
I believe it was
November 24th, 2022, Your Honor.
November,
November.
yeah. Sorry, I didn't write that down.
22. So fire department dispatched. Okay. And what happened next?
So the fire department was actually dispatched twice, apparently. The first time was at approximately 4 a.m. And they go to the apartment 209. They make contact with the defendant, but he refuses to open the door. He tells them that he's nailed it shut. They force entry. He has a knife in his hand. They tell him to drop the weapon, but then when they search, there are no signs of fire. So then they get another call at around 4:47 a.m. And then this time when they arrive, there is the fire alarms going off. Occupants have been evacuated. And they meet with the witness who was told by his neighbor that she suspected, or there was smoke in the hallway. He finds that it's coming from 209. He forces entry and he sees a fire on a table near an electric stove in the center of the room. and the defendant has barricaded himself in the restroom. The witness, which I'm assuming is either another resident or the manager, puts out the fire with an extinguisher, and then said that the defendant walked out and just left the vicinity. Police were able, or I'm sorry, the fire department said that they were able to trace the origin in room 209. And they said that it was a open flame or heat source, portable open flame or heat source. Then they go back and they review the 911 calls, and they believe it's the defendant calling saying, you better come now. He was saying that he was going to start a fire. And this was around 4:26 that once again, he said there was a fire occurring in his room. And then at 4:50 is when they get multiple calls from neighbors about smoke in the hallway. Because it's a hotel.
What is his criminal history? Well, I think I may have some of that from before. He's been to prison in 2015 for ag assault. Is that the only time he's been in prison?
Yes, Your Honor.
No, I'm sorry, Judge. He has a lot of history from California, according to the rap sheet. He had a 1983 unlawful sexual intercourse with a minor, 2 years prison. Then there was 1991 evading a peace officer, causing serious bodily injury, San Bernardino, 16 months prison.
Did he go to prison on the sexual assault with the minor?
Yes, it said 2 years prison in the rap sheet. That was out of Riverside, California.
I'm sorry, Ms. Espinosa, what was the second charge?
You know what? The second one, evading a peace officer causing serious bodily injury.
Thank you.
Let me
When
pull
was
up the
that?
rap sheet.
What year was that?
Give me 1 second, Judge. I'm so sorry.
And I mean, again, I'll look at the rap sheet before I, what do you call it? The social, the report. I'll look at it in its entirety, but I just wanted the highlights of it.
Yeah, it's a long rap sheet. I don't want to get any.
Yeah, I don't want to go. I don't need to go into all of it. Like I said, I will look at all of it in a few minutes, but I will also, I just wanted the ones he's been to prison for, where he's actually served time. So you've got the sexual assault of the minor, and then you've got an evading with serious bodily injury of a peace officer. And when was that?
That was, sorry, I just wanted to make sure I had the right guy because I needed to look at the rap sheet again. That was in 1883.
1983?
Oh no, the evading 1991. Sorry, Judge.
1991. Yeah, the sexual assault of the minor is 83. 91. And you said he got how much on that one?
16 months prison.
And you said that was out of did you say that was out of San Bernardino County or something?
San Bernardino, yes, Your Honor. And then they're in 1995, Long Beach, California, sexual battery.
What do you get for that?
That was 60 months.
I got probation. There was a girlfriend, I got probation on that.
Mr. Sandoval, please don't address the court, please.
Okay. Yeah, it is being recorded, and so I mean they'll now have your comments there. So, all right. All right. Any other prison sentence out there in California?
96 of, this is weird, violate National Firearms Act, felon in possession of a firearm out of California, 92 months federal prison.
Okay. Well, that's at least probably 1, 2, 3, 4, at least 5, maybe 4 or 5 prison sentences between California, federal, and state of Texas. Also, this case alleges something very serious in an apartment where other people could have been injured at a very unusual time of the day where people would be sleeping. Yeah, I'm not going to reduce the bond. Denied.
Understood, Your Honor.
All right. So
Your Honor, would you like me to submit that?
I want I want the bench warrant immediately
Yes,
on
Your
this. All right. And you all you can talk with the prosecutor later about how to resolve these cases, and we shall proceed from there. Do we have a trial date yet set on this? We need to have a trial date set.
Your Honor, if I may, Ms. Romero has contacted ADA Espinosa a couple times now asking for a rec. So if ADA Espinosa could please get us a rec, we'd really appreciate it.
Yes, and I'm so sorry. I did an updated rec today to 5 TDC.
5 TDC. Okay, I will let her know. Thank you.
Yeah, to run concurrent with the revocation.
With the revo. Okay. Thank you.
Thank you.
Okay. All right, very good. Thank you. Was there anything else?
Nothing from the defense, Your Honor. Thank you.
Thank you. All right, thank you. I think we're done then. Is that all that we showed from the annex, I believe?
Can I say something, Your Honor?
Certainly, anytime you
Okay.
want, sir.
Well, the fire department, they released me, right? Because somebody was trying to get me.
Your Honor, Mr.
And-
Sandoval, please don't talk about the facts of the case on the record,
Well, the
please.
fire
It can be
department
used
let me
against
go.
you.
Fire
Mr.
department-
Sandoval, anything you say on the record can be
Let me
used
go.
against you. I'm please asking you to stop talking.
I have
Anything
to
you
speak
say, the
because I didn't do
prosecutor
nothing
can
wrong.
use against you.
I understand, but I did nothing wrong. I called 911 for help. I'm the victim. I was asking for help. People were trying to get me. And the fire department let me go. I gave him my ID because I did nothing wrong. He goes, go ahead, leave. He knew something was wrong. He got my ID and let me go.
All right. Well, like I said, they'll fully investigate this for you, and we'll see what happens.
I appreciate it. I was doing good out there, working everything, making like from $450 to $900 a week. Put a lot of money back into the economy.
Well,
Right, sir.
all right. Well, we're done with the hearing today, and thank you very much.
I appreciate it.
Thank you, Your Honor. May I be excused?
You may.
Thank you,
Yes,
Judge.
indeed. All right. Thank you. We can go off live. Are we off? No, we're not off live yet. Go offline.
David.
Yes, I know.